And when enough people and enough hundreds got together, they would form a county, which was the next level of government. Now, we decided that because our book is basically a manual, when you get right down to the bottom line, it's a manual on how to start your own hundred with people of like mind. And it uses the same law that the ancient English used, the common law, or as we say, the lex non scripta. You see, you walk into court, assuming you're stupid enough to go into court, okay, because none of our people make an appearance, because you're dead meat if you do, and for reasons which I'll come to in a minute. But if you're talking to a judge or a lawyer and you say, well, the lex non scripta says, you know, right, the judges don't know anything about Latin anymore. You know, they gave that up in college. It was too cumbersome. Besides, it's a dead language, which is precisely the reason why we use it, because it's not subject to interpretation. A dead language doesn't change its meaning. You see? So you say the lex non scripta, law not written, lex, law, non, not, scripta, written. Lex non scripta, you're saying the law not written, which is the superior law to all forms of law except the Scripture, which is the highest law of the land. And it is today, still today, the law of the land, and is the superior jurisdiction in every court in these United States, if you can call them courts. They're a kind of court. All right. The court, by the way, the court's not the judge, it's not the building, it's not the lawyers, it's not a plaintiff and a defendant. It's a process, the paperwork. Okay, because without the process, there isn't any court anyway. All right, so just clear that up for a second here now. When I say if they're a court, in fact, after considerable research, we discovered that all the inferior courts in these United States, below the state Supreme Court and below the United States Supreme Court, are military courts or tribunals sitting in summary court-martial proceedings against civilians. That's why, guys, since none of those courts can hear constitutional arguments or statute arguments or any other kind of argument, that's why when you go into such courts, you lose as if you were constantly taking a knife to a gunfight. All right? It doesn't fly, because that's why the district attorney said to me way back when, in my 15th or 16th appearance in court, that the only law in this court comes out of the mouth of the judge. Because in military courts, the judge's word is law, not the Constitution, not statutes, not anything else, except for the 1984 and 94 Manual of Courts Martial. And I hardly recommend that book to you, by the way. That's the 1984/94 Manual of Courts Martial. It's a red-covered book. It's about yay thick, and it's in the 8 by 10 format, roughly. All right? Small print and that whole 9 yards. All right? Of course, that book's out of print now, so it may be hard to find one. We just happened to find it at the right moment in time. At any rate, we said, well, now, wait a minute. How in the world now are we going into military courts? I mean, you know, what about the Constitution? And what about the, you know, the law and all these other kinds of things and our rights and everything? Well, as it turns out, in doing research on the matter, we went all the way back to the War of Northern Aggression, or the War of Secession, or the war between the states, whatever you want to call it. For my personal preference, it was the War of Northern Aggression. That was specifically, deliberately, and with malice created by one A. Lincoln in order that he might become the father of a new country. And that's why we call him the father of a new country. Now, that's kind of a harsh statement to make about someone that seems so well respected in all the textbooks and all the television and the media and everything else, but the bottom line comes down to this. In 1860, the division began to occur in the Congress. In 1861, 7 southern states walked out of Congress. The Congress was thus left without sufficient members or attendees or representatives in order to form a quorum. without a quorum, and if you read any book on parliamentary law, without a quorum, you can't do business of any kind, except submit a motion to make a quorum, that is to go out and get people and bring them in, or to adjourn. And if you fail to adjourn properly, your deliberative body, or in this case the legislature of the United States of America, becomes sine die, another Latin term, means literally without day. In other words, if you create a little deliberative body, like a small government of some kind, or if your county's civil government, and I keep using that word civil as if they really had law, doesn't matter if they adjourn improperly without setting a day and time set certain to reconvene, they cease to exist according to the rules of the parliamentary law under which the Congress and all deliberative bodies of government in this country sit. In other words, guys, if you don't set a date to get back together again, whether it's day after tomorrow, next month, next year, or whatever, all right, you cease to exist in law as a parliamentary body. And thus you are left without day, or without a day to reconvene, and you become, without day, sine die, and you cease to exist in law as a valid, constitutional, lawful, or otherwise body. Now, what evidence do we have for this very fact? It comes down to this. If you go down to your local library and you pull down volume 1 of the Titles and Codes, you'll see there's a table of contents there in the beginning of it, right? And you look at all the titles, and in the top left corner you'll see Title I, the Presidency, Title II, the Congress, Title III, the Judiciary, etc. And if you don't skip by too quick, you'll notice there's an asterisk next to Title II, the Congress. You go down to the bottom of the page, and the asterisk says resolution, not positive law. Now, there's no asterisk next to Title I or Title III, but there is next to Title II. A few months after the Congress walked out, A. Lincoln, actually this is just a few weeks, A. Lincoln seized control of the government and issued the very first executive order to call up 75,000 troops. Executive Order number 1, April 21st, 1861. With that executive order, Lincoln began a course of action which formally terminated the Constitution for the United States of America as the supreme law of the land and ended the life of the Republic. The formal death of the Republic took place on September 22nd, 1862, with the issuance of the Emancipation Proclamation. The reason why that date is chosen is because for the first time in American constitutional history, Abraham Lincoln asserted federal jurisdiction over black people in the states, and at the same time asserted federal jurisdiction over white people within the states. And for those of you who've done your study of history, you know there were no citizens of the United States until after the war between the states. Before then, the United States government had no citizens it could tax, which is one of the reasons why they created the 14th Amendment, by the way. All right. They knew they probably couldn't get away with it, you know, by including white people, so they just went after the minorities who didn't have the knowledge and the training of the common law that the average white person had. Now, all this was set up, of course, by a decision rendered by Chief Justice Taney in the famous Dred Scott v. Sanford case. And there's an awful lot of people in the movement that keep citing that case for various reasons and arguments. My recommendation to you is that you stay away from that case for one reason. Because every authority in law that I have ever read on the matter knows the case was contrived by Justice Taney on grounds that cannot be sustained in law. Why is that? Because Taney's whole argument comes down to this, that there were no free blacks who owned property in America prior to the Constitution.